this bill to the House.
The question is that the motion be agreed to. The Honourable Leanne Dalzell.
Mr Speaker, thank you. I'm pleased to speak in the first reading of the Consumer Law Reform Bill as the opposition spokesperson on consumer rights and standards. And because this bill traverses both the consumer rights aspects and some consumer standards issues, product standard issues, then I'm really pleased to be able to make this contribution. I just want to reflect a little bit on the journey that this bill has taken to get to here. I have in front of me a copy of a speech that the Honourable Heather Roy gave in November 2009, and in that speech she talked passionately, as she often did, speaking for the Association of Consumers and Taxpayers. I think we forget that the ACT Party is an acronym for the Association of Consumer and Taxpayers, and she was delighted to be the Minister of Consumer Affairs, seeing it sit with the ACT Party. And so I certainly look forward to the Minister John Banks's contribution to this debate, because I'm sure he'll want to, make a substantial contribution, recognising that both Heather Roy and John Boscawen, after her, took on this really important role. When Heather Roy spoke, she spoke about one law, one door. I guess a variation on the one law for all that the ACT Party was normally referring to. But the one law, one door concept was actually one that I think had some resonance in this field, because there are a myriad of pieces of legislation. There are I think, seven consumer laws and 2 business laws that this piece of legislation relates to. And I think that the concept of bringing them together into one legal framework is a very positive one. So we're very pleased to be seeing the bill in front of the House, and obviously we'll be supporting it to the Select Committee. The one door, though, doesn't necessarily find itself addressed in this particular legislation, and I think it's interesting that the Minister concluded, I think, by referring to some of the things that were not in the legislation, particularly in relation to some of the Australian issues, unconscionability, and making claims that cannot be substantiated, which are unfair practices, and that the Minister, I think, was indicating that the Select Committee could actually have a serious look at those issues, and that he would be willing to... that they are in it, but unconscionability is not. So, and that is certainly something that's reflected in the Australian legislation. I think with the general focus on the single economic market, I think it would be a good thing for the Select Committee to have some detailed look at that. I know myself, when I was a Minister of Commerce, it was something that I was quite keen to see us pursue in the legislative frameworks that we were considering at the time. So I think it's helpful when a Minister does say that there are opportunities within the Select Committee to hear what submitters have to say, and then potentially report back something with some significant changes. I think is a positive thing, so I'm very pleased, and I certainly was the history of the relationship that we had with the previous Minister of Commerce and the previous Minister of Consumer Affairs as well, so I'm pleased about that. But I should reflect on the fact that this bill was on the legislative timetable in 2010 and in 2011. So it is a little bit of a shame that we've waited till 2012 before it's actually been introduced. But it is here, and I want to speak positively about it because of what it is attempting to do. But I want to do something even more important, and I know that none of the people on that side of the House are going to be surprised at what I'm going to refer to, and that is the 2 regulatory impact statements. And I just want to say that these are the best regulatory impact statements I have seen in my time in Parliament. They are the best, and I would like every single minister in this government to have a good look at these regulatory impact statements and think to themselves about how they might want to ensure that all regulatory impact statements meet this standard. This has set the bar, in my view. and that is because the regulatory impact statement, the first one that was prepared for the legislative timetable in December 2010, started off with the preliminary work. So this document, I mean, I really just do want to congratulate those that have put it together, and it's probably not surprising that the Ministry of Consumer Affairs sits with the MED, and the MED would have certainly been looking over their shoulder in terms of the detail of this, and I'm sure the Deputy Secretary would want this to be as good as it has been. But to set out what the status quo is, the status quo actually identifies what the regulatory frameworks are at the moment. And so you've got a very simple snapshot of what all of those pieces of legislation do in a nutshell. And I think that's an incredibly useful starting point. But then the most important part of the process, because you cannot get to the end point until you do this, and that is problem definition. And I have to say, it warmed my heart to see a document that actually said problem definition. And the problem definition talked about a number of factors that had been brought to the government's attention by way of some analysis around consumers' knowledge of their own rights and where they could go to have them addressed. So I just cannot really applaud loudly enough the extent of the work that has gone into these statements. The next is the regulatory impact analysis, and what it has done is looked at consumer and business detriment as a result of consumer laws not meeting the objectives that are set out using the OECD Consumer Policy Toolkit framework. And that analysis looked at unfair contract terms and standard form contracts, unconscionability, making claims that cannot be substantiated, lay-by sales, unsolicited direct sales, unsolicited goods and services, Consumer Guarantees Act statutory guarantees, and auction conduct and licensing. And then the document goes through each and every one of them, and they do it in a very simple form that people can follow. It says what is the problem. It talks about the measure of consumer detriment and the magnitude of the problem. It then talks about the nature of the detriment, the scale of consumer detriment, and the measure of business detriment, and then the likely consequences of taking no policy action, namely the cost of the status quo. And that identifies the cost to consumers, the cost to businesses, and the cost to government. I mean, I honestly have not seen a document more significant than this in considering a regulatory impact analysis. The policy options are then set out: no change, or add provisions to the Fair Trading Act, the same as in the Australian consumer law, and then add provisions to the Fair Trading Act on unfair contract terms, add provisions to the Fair Trading Act on unfair contract terms similar to, etc. But the Ministry favours a particular option and sets out both the benefits and the costs. And it goes through each one of those headings on the same basis. So again, I just think it is absolutely extraordinary that it has gone to this extent of detail, and I am very pleased to see it. The second regulatory impact statement relates to the changes, additional options that were identified to address problems that have been identified with consumer laws not adequately meeting the objectives of consumers who are able to transact with confidence and businesses which are able to compete on a level playing field. And again, this identified areas where the public didn't know what their rights were, and in fact businesses found it difficult to work their way through a myriad of issues. And one of the classic ones is the extended warranty. I don't know how many members in this House have had the experience of buying an appliance and being offered an extended warranty, which is completely and utterly meaningless if you don't comply with the obligations under the legislation. And so I think that the Ministry of Consumer Affairs can take great credit for the background work, which I think will facilitate the work of the Select Committee. Labor will be supporting this legislation to Select Committee, and we look forward to its progress.
Called Todd McLean.
Mr. Speaker.